really, and with apologies to Justice Modan Lokur that I'm going before him. Actually, I have a family commitment, and therefore, sir, I beg your permission for this, sir. So the topic all of us know is whether UAPA and sedition laws have a place in our statute books. Justice Deepak Gupta rightly pointed out that in the present form as it is not acceptable. And I would also agree with him when he says that why is it not permissible? I would say because it is vague. The definition in section 15 is so vague that it is susceptible to misuse. And therefore, what now has happened is that instead of thinking that it is to be used, for sovereignty, for protection of sovereignty of the state, it is being used for sovereignty or protection of a political party. Now, the hallmark of good legislation is this, that it should be definite and it should be incapable of misinterpretation. Here, unfortunately, it is so vague and therefore it is misinterpreted. A person who says that cow's urine is not good for COVID is also put behind the bars for UAPA. Now, that is absurd, absolutely. And it is because of this, the vagueness in the act, that, it is being misused. Now, the second thing is that we must understand the chronology. आजकल क्रोनोलॉजी तो chronology बहुत पॉपुलर शब्द है, तो इसको हम भी अपने इस्तेमाल करते हैं. As we know, that the United Nations Human Rights Convention that came in 1948, and Article 11 specifically said that every person has a right to presumption of innocence. After that came our constitution in 1950, in which Article 23 said that a person has a right to has a right against self-incrimination, which in effect means that he has a right to silence. After that, in 1976, came the International Covenant on Civil and Political Rights. Article 14.2 once again reiterates what is said in the human rights document. So it is unchallenged that actually the presumption of innocence should not be dislodged. Now, what has happened is that there are certain things, that we need to understand about criminal jurisprudence. There are certain basic fundamentals where the present UAPA is concerned, we need to understand. One is presumption of innocence. The second is right to silence. The third is burden of proof is on the prosecution to prove its case beyond all reasonable doubt. And then fourth is the higher the punishment, the greater the burden on the prosecution. Now, when we see section 43D, it says that that is of the opinion there are reasonable grounds for bearing that the accusation against that person is prima facie true. So you cannot grant bail to the person if it is prima facie true. Second is 43E, it says that the court shall presume unless the contrary is shown that the accused has committed such offense. Now, unless the contrary is shown. Now, who is supposed to show this contrary? Obviously, the accused. Now, when, our Evidence Act 106 is very clear that it is only when facts within your special knowledge is there, only those facts need to be proved. Otherwise, the burden is on the prosecution. So when 113A, when it was amended, the Evidence Act 113A about dowry death and suicide, it did not say that it is to be shown. The contrary is to be shown. It only said that once the prosecution has proved its case, then you are to presume all this. Now, presume all this, the courts have already said that just because there is a presumption clause does not mean, that the prosecution is not supposed to discharge its initial burden. That has to be necessarily discharged. Once that is done, only then the presumption could be shifted or the onus could be shifted. The point is here you have put, the defense as well as the prosecution in equal footing. So once the prosecution does one work, then the accused is supposed to, the defense is supposed to show that he is not guilty. Now this is absurd. It is not proper in an adversarial system. It cannot be done. Now the second thing, is about on conditions of bail. The point is, that the word that is used is the court shall not grant him bail unless prima facie they shall not, the person shall not be granted bail, etc. They do not specify which court it means. Now, as we know, that we have an inverted pyramid where discretion is concerned. So the Supreme Court, it comes right on the top and it's got the widest discretion. Then comes the High Court, then the Session Judge or Magistrate, whoever. The point is that the designated court is the Session Judge. After that, the High Court, when it comes to the High Court, it does not have any wider discretion, nor does the Supreme Court. And therefore, in the article I've written, so the Supreme Court becomes interchangeable with the magistrate or the designated court. This is absurd. You cannot possibly do it. The High Court has to have wider discretion. That's the whole concept of CrPC. That was why, that there was separation of powers, etc., etc. When the new court came into existence, they made sure, that the conditions for bail, that was bifurcated in two sections. One was for the magistrate and the second was for the High Court and the Session Judge. How could you just disregard this? And when it, unfortunately, when TADA, the provision of TADA, when it was challenged before the Constitutional Bench in 1967, I think it was. So what happened was that in TADA, there was no appeal to the High Court. The appeal was to come to the Supreme Court straight away. So the High Court was bypassed. There was, a challenge to it. This challenge, the presumption of innocence, because there was about the conditions, twin conditions on bail, confessions, etc. The Supreme Court completely forgot to answer the question that what happened to the presumption of innocence. And therefore, it says that in the national interest, the legislation can bring in such acts, such laws. The point is not, that whether the legislature can bring or not. The point is, whether the Supreme Court as the judiciary, whether courts, as the protector of human rights, as the protector of everyone's rights, is failing its duty to not think that, in future, there could be a possibility of a misuse, which we are seeing now. Now, what is happening? The High Court doesn't do anything. The Supreme Court says, if the High Court does, the Supreme Court says, how come, you've done it? And the High Court says, no. The Supreme Court also says, no, we're not supposed to grant bail. This is absurd. What happens to a person's, the person's protection of civil rights? So you can go to hell, the executive can commit excesses, but the courts will not be able to come to, your rescue. And now why did we come to this pass? Because of the Constitutional Bench decision, I would think. It is unfortunate, that this happened. Now, in the end, I'm also in a hurry, and I'm sure all of you are also sufficiently bored, but I wanted to just, TADA, it's, all these acts, the amendments in UAPA came in after the 9/11 happened in the US in 2001. And then, the UN, they sat together, and the UN Security Council, they passed a resolution called 1373, where the states are supposed to endeavor, etc., for security, etc. So it was all, concerning whatever had happened with the US. I'm not, concerned with that. Later on, what happened was that another amendment by which, all these rights, etc., the presumption of innocence, etc., was laid to rest. That came in the year 2008. And there, in the objects and the purpose, etc., they mentioned a number of resolutions of the UN. They all pertain to the Middle East, to the Al-Qaeda, sanctions against Osama, etc., etc. How is it relevant to our domestic laws? I don't understand this. And therefore, what has happened is that recently, this is now very, very important. Every year they keep having some kind of a meeting in the UN. And recently on the 12th of January, 2021, Ambassador Richard Mills, Deputy Permanent Representative U.S. Mission to the United Nations, he delivered a lecture as in the 20th anniversary of Resolution 1373. I'll just read two lines. As colleagues have mentioned, history has also shown us over and over again that measures to prevent and counter terrorism that come at the expense of human rights and the rule of law are counterproductive. That is why the United States will continue to object to certain countries' actions to engage in mass detention of religious minorities and members of other minorities. Now then, thereafter, governments, including governments sadly represented in this council, must not use counterterrorism as a pretext for stifling freedom of religion or belief or other human rights and fundamental freedoms. So even the Security Council has come to this conclusion that actually there is blatant misuse. There is an abuse of these provisions, and taking the refuge, hiding behind these high-sounding resolutions of the UN. This is what is happening, and nobody raises a question. But how could the courts have failed us? I fail to understand this.